Let's go to top lawyer Nick Freeman now on this situation. So, Nick, in future, the only get out for anyone who's got 12 or more penalty points on their licence should be if disqualification would cause real and severe hardship. Would you have a battle on your hands to argue that one, Nick? Good evening to you.
Good evening, Eamon. Well, I'm sorry to say, but the law has always been there has to be exceptional hardship. And what we've got now is a consultation paper taking place with recommendations in terms of how to advise the magistrates. And the recommendations are actually going to, in my opinion, mean that there will be more people driving with 12 points rather than less. So this is a lawyer's paradise, what's proposed.
Really?
For a whole variety of reasons.
Yeah.
But just to make it clear, that you said, well, look, if you lose your job, that wouldn't necessarily be exceptional hardship. That has always been the case. And there has been nothing new that will cause there to be more people off the road. In my opinion, there will be now less people off the road and more cases where there is exceptional hardship.
Except I'm looking at the figures, and it says a third of drivers dodge bans because they can persuade the magistrate that they should keep their licence on those grounds.
Yes, but it's on the grounds of exceptional hardship. And at the moment, what the defendant has to do is he has to persuade the magistrate that there would be exceptional hardship as a consequence of losing his licence for a period of time, and that the minimum period. When you get to 12 points, the law is very simple. You're off the road for at least 6 months. Okay, that's the general rule. There is an exception if there's an exceptional hardship, and the burden was or is currently on the defendant to prove that on the balance of probabilities. Mere inconvenience is insufficient. The fact that it will cause you hardship, but it's not exceptional. So the fact you lose your job, for example, if you live with a wife who could afford to make the payments, or you lived at home with your parents, loss of job would be a real pain, but it wouldn't be exceptional hardship. And the magistrates only have a discretion if there is exceptional hardship. So that there is nothing new here. And what is interesting about what is being proposed is, first of all, they're talking about it, in my opinion, a completely new area, which is called the Equal Treatment Bench Book. And what courts are specifically going to be asked to consider is whether or not the litigant in person suffers from potential prejudice because of disability, gender, racism, religion, anything of that sort. So if, for example, you're a Jewish person and you look very Semitic and you lived in an area where you might encounter problems, the courts are now specifically directed to consider that. Or if you live in an area where there are a lot of stabbings and you say, look, I don't think it's safe, and these are the statistics, the court must consider that. If you're disabled or if you're gender fluid, these are things now that the court is directed to consider, which is, they could consider it before, but they're being specifically directed to.
Fair enough,
which in my view is a completely new area, a new direction.
As you say, a lawyer's paradise.
Well, it's a lawyer's paradise because they're also saying that the court can... Normally what happens is if you're going to argue exceptional hardship, you give sworn evidence. You take the oath and you say, look, this is why I would, or somebody else, an innocent victim, would suffer exceptional hardship. The courts are now being asked to consider just some evidence, and it doesn't need to be sworn. And they're also saying the implication is that the burden of proof is going to be below the balance of probabilities. They say some evidence as opposed to evidence on the balance of probabilities. So in my view, the bar is being lowered all the time. And there's one other factor which is very interesting, and it's important to bear in mind, and the consultation, if they come into guidelines, they have statutory force, which means that the courts have to follow them. And what they're being asked to do, and what's being recommended, is that the court consider a discretionary disqualification first. So if you've got, say, 9 points for 3 speeding offences, and you get a 4th one, and you're doing, say, 37 in a 30, the court would be asked to consider now whether you should be disqualified under a discretionary ground. It's a different section. And if they said, well, yes, we think you should be disqualified under a discretionary ground, and they now have to consider that first, you get no points, so you don't tot. So you get typically a 2-week ban. You still have 9 points on your licence. The totting up ban, of course, cleans your licence, but the discretionary ban doesn't. So you have 9 points on, you have a 2 weeks off the road, and then you get your licence back, and you're avoiding a 6-month ban. Yes, you've got to drive carefully because there's a sort of Damocles hanging over you, but the difference is now there was a case which said you have to consider a discretionary ban first, and they've now basically saying this is going to have statutory force. That is what the court's got to do. They must consider that in the context of previous driving. So they'll look at your driving record. So if, for example, you've got a no insurance and 6 points, and you've got a due care and attention of 3 points, and you've got one speeding, which takes you up to 12, they will probably be persuaded to give you a short ban under their discretionary powers, so you don't actually fall in jeopardy of losing your licence for 6 months. So, as I said a few minutes ago, in my opinion, whilst these guidelines are designed to make life harder, I think they're going to have, I'm very confident they're going to have the opposite effect. And can I just say that when it's Section 35 of the 1988 Act, the Road Traffic Act, Offenders Act that we're talking about, that the whole purpose behind this was a very legitimate one. And what they said was, look, as a general rule, if you get to 12 points, you're off the road for a minimum period of 6 months. But we realise that under certain circumstances, the consequences of that are going to be so catastrophic, we want to give those people one more chance. And that's a chance that can be argued once in a 3-year period. And what's happened is the legislation was drafted in a clumsy manner. And what that enables people to do, with the help of either themselves or lawyers, is to, for example, get to 9 points and then commit, say, 5, 6 different offences in different areas, get them all pulled together, plead guilty to all of them at the same time, and then successfully argue exceptional hardship, because there would genuinely be exceptional hardship in a particular case. So that's why you get people with 40 and 50 points on their licence not off the road. The spirit of the legislation was right, and what's happening is the courts are avoiding the spirit of the legislation because the actual draftsmanship was clumsy, and it's affording smart lawyers a way around this legislation. And what should happen, and I've said this before, is the legislation needs to be redrafted so that it gives effect to what Parliament intended. Okay. And that makes sense, If you commit 4 offences and you're driving, 50, 60,000 miles a year, why would we not want to give you one final opportunity, but not 2, 3, 4, 5, that's too much, but one more chance, and that's why this story's come to the front.
Well, Jackie, you've been listening intently there to Nick.
It's quite complicated. I think you sort of have answered my question. Do judges ever consider the type of speeding that the person's done? So you're up to 12 points, but, if you're a boy racer who is constantly, massively breaking the speed limit, and that's where all your points have come from, then obviously you're a serial offender. If you're someone, as happened to me before, not recently, but years ago, where I've been in an area I didn't know, and the speed limit changed, and I was going a couple of miles over the speed limit, and then I got points for that, and the same thing happened again in another part of the country, and it was 2 miles over the speed limit.
You were a serial offender as well.
Well, I was, but it was total. I didn't know the road, and it was a mistake.
Twice. All right, well, Jackie, can I say 2 things? First of all, there's a tolerance threshold of 10% plus. Then it was probably 10% plus 2. So if it was 30 mile an hour speed limit, you wouldn't be prosecuted anything less than 36 miles an hour. Now you'd be prosecuted at 35 miles an hour. That's number one.
When you have those roads where, it's 40 at one point, and then it might go down to 30, and then it goes to 40 again. And if you don't know where you are, you might not be aware of where the change happens. That sort of thing. That's not the same as I'm going to bomb down this road as fast as I can because I've got a fast car.
But those people, Jackie, that you're referring to, they don't get penalty points. They're removed from the road. So if you're going 60, 65 miles an hour and a 30, 40 limit, the chances are, the sentencing guidelines are to disqualify. And what happens is they get disqualified, but they don't get penalty points. And a lot of defendants who actually want to commit those sort of offences would prefer to have a disqualification, because that disqualification is normally much shorter. It's typically 7 days to 28 days, maybe 56 days. And they'd rather have that so that they don't actually ever reach the threshold of 12 penalty points.
Okay.
So again, that's an area that needs looking at.
And as does the speed limits. What's your speed?
Well, the speed limit, in my view, Eamon, in certain circumstances should be increased, not reduced.
In what circumstances?
If you look at the average speed that we travel on our motorways, it's pitiful.
Yeah, and there are some roads that have got 3 lanes where, it's 30, and you think, why is this 30? It could easily be 40 or 50.
The whole system needs to be reappraised, doesn't it? By people who are on the roads, who understand what's happening, And I'm afraid that doesn't appear to be what's happening here.
Here, let me ask you, this may sound very unprofessional, but when we were chatting earlier and we were talking about excuses for speeding, you weren't the man who defended Sir Alex Ferguson when he had a squeaky bum time, were you?
I'm not sure his bum was very squeaky on that occasion, actually, Eamon, but yes, I was.
Okay.
And
did you win that? Did you win that case?
In response to that, it wasn't. He was acquitted. He was found not guilty because of a medical emergency. So can we just correct that, please?
Okay, my friend. Okay. Very good. That's Nick Freeman. Thank you. No one in the business is Mr. Loophole top lawyer. Nick, thanks for explaining all of that and going into great depth. Thank you for your time.
Thank you, Eamon.
Appreciate it very much.
There was a lot of detail there, wasn't it?
Lot of detail there.
Process that.
If you've got a view on speeding, how tolerant would you be? How tolerant